This panel is about confidential sources, journalists' use of confidential sources. Slight mix-up. I'm not, in fact, the person who's supposed to be chairing it. Jamie Cameron, who's kindly become a panelist to replace somebody who couldn't come, is in that spot. And we have, again, a very distinguished panel with journalists and lawyers. Happens to be the lawyers on my left this time, but that's just an accident. On my furthest right is Kevin Donovan, investigative editor at the Toronto Star, investigative reporter extraordinaire. I first met Kevin when he was just a student at the University of Western Ontario, which seems like only a few years ago.
Probably about 27 or 28.
And he has gone on to do an incredible array of stories, very important stories, award-winning stories, and now he helps head up the Toronto Star's investigative team. And you may have noticed, if you've read the Star, they have a lot of good investigative journalism that makes the front page and changes things. Next is Julian Scher, who is, again, an investigative journalist extraordinaire, currently primarily a writer for the Globe and Mail. In the past has worked for all kinds of other news organizations, particularly the CBC. He's been a TV documentary maker. He's published 3 award-winning books. He specializes in true crime, and I can tell you that's not an area that's easy to write in, and he's done incredibly well in it. He has a website, julianscher.com, which I invite you all to go to and learn a lot more about him. On my left immediately is Gail Gove, is that right? Mm-hmm. Good. Who is with the Wall Street Journal and Dow Jones, and acts as the litigation and press attorney at Dow Jones, mainly for the Dow Jones local media group with local newspapers in the Northeast and West Coast. She conducts pre-publication review and all manner of pre- and post-publication issues arising from publication of content, including subpoenas of Dow Jones reporters. And her background's interesting because she not only has a JD from New York University, but she worked as a fellowship attorney for the American Civil Liberties Union at one point. And my furthest left is someone that nobody here knows, but you really should, because I don't think she's been properly introduced. Jamie Cameron is Canada's leading free expression academic who has written widely on free expression issues for as long as I've known her, which is a long time. Been at Osgoode since 1984 on the faculty, heads up the annual Constitutional Cases Conference and publication that Osgoode produces. And I've known her more recently because she's acted as counsel for the Canadian Civil Liberties Association in the Supreme Court of Canada in important 2B cases, WIC Radio on the fair comment defense in libel, and more recently the National Post and Globe and Mail cases involving confidential sources. So you can see why everybody's on this panel. I'm Brian Rogers. I was on an earlier panel, so you know who I am. And what we thought we would do is start off with a journalist, give the lawyers some chance to weigh in, and then turn to Julian Scher to wrap things up. So Kevin is first to bat.
Thank you. Thanks a lot, Brian. I decided to go, or I asked to go first because it worked really well for me on the weekend. I was at a 50th birthday party, first of many because I'm turning 50 next year, and it was a roast, and I actually was singing, and I don't sing. And my theory being, if you go first, then all these other fabulous people follow you, and they forget what you did. So that's my theory today. The phone rings. "Have I got a story for you?" she says. "But you have to keep my name out of it." Or you hand a copy to a rumpled fellow with a bag stuffed full of documents. "This is pretty big," he says, voice shaking a little bit, "but you can never tell who gave you this stuff." Or in the course of research on a story, you find someone who can corroborate information you've already been given, but only if you keep that person's identity secret. Or, as happens more and more these days, an email arrives from what is obviously a concocted address. Joe's source, I got one of those, says he has the goods on a political leader, but before meeting you must agree to one thing: confidentiality. Before the public, before a court, buddy, you got to take this to the grave with you. Is this fiction or some kind of fantasy? No, actually it happened over the last month to me in each case. What's a poor journalist to do faced with all this stuff? Well, remember the old expression, don't buy a pig in a poke. A poke, in case you don't know this, in medieval times was a sack. And there were a lot of cats in the old days and not a lot of pigs. And people would try and sell you something that was a cat, and you really wanted to buy a poke. The idea is don't enter into a deal unless you know what you're getting and who you're dealing with. When I get calls like that, as many journalists do, I start asking questions. If the person is legitimate and has real information that will expose something in the public interest, then I'll talk to that person about entering into that deal. But if they resist giving me the details and threaten to go elsewhere, as they often do, then I usually let them go, because they're probably not legitimate. The ability to provide a confidentiality promise to a source is very important. Where it gets sticky is the reason for confidentiality. Is it because the source has a fear of physical retaliation or even death? Does the source fear losing his job? Or is the source embarrassed about something? Was the source perhaps part of a criminal act and wants to rat out the ringleaders? These are the types of questions we have to answer. All are valuable reasons in the source's eye, but a court would not look favorably on a reporter who shields the source just because that person was afraid of being embarrassed. I try very hard to only use sources to get me information. This is the best use of confidentiality agreement because if it works, nobody ever knows there was a source. I have two quick examples that I want to share with you. John Hondrick will be aware certainly of one of them. One is a case where a criminal court asked me to reveal a source, and the other is a case, a more recent one, where an institution outed a source, but I never did. Some years ago, I was approached by an Iranian gentleman in Toronto who owned a bar. He told me that provincial liquor inspectors were shaking down new Canadians who didn't know the system and telling them they had to pay a bribe, $500 or $1,000 to get a liquor license. We tried to investigate this in the normal fashion, but ended up setting up a fake bar application, a fake bar, and eventually made a $500 cash payment to a liquor inspector. The story is actually a lot longer and involves some funny things, including me being arrested, but when all the dust settled, the police arrested the inspector and charged him with corruption. I was summoned to testify. His defense lawyer wanted to know how I got the story, how I got onto it. Well, I refused to answer the question, and arguments were made by the Star's lawyers. At that time, I think Mark Rosenberg, actually, who's now a judge, was my lawyer. The judge on the case ruled that the identity of my source was just simply not germane to the issue against the inspector. Well, I lost my big chance to go to jail and become famous. The other case is one that still troubles me, and it happened over the last couple of years. It shows you the lengths that an institution will go to out a source. I actually can't tell you what the institution is because I still must keep my promise to the source. But it involves a matter of great public safety in the City of Toronto. A member of an emergency services department, which includes police, fire, or paramedics, so it's one of those, told me of a serious problem that threatened lives in our city. The only way to get the information was for the source to obtain the data I needed from city computers. The person did this and provided me with the information. The stories caused a fair bit of a stir, and after they were published, the city agency went on a witch hunt to try and find my source. They asked me who the source was, and I predictably told them to stuff it. But then they went and did what I would imagine was an illegal search of various employees' computers, and they determined, in their opinion, that they had found the source. As punishment, this source, who I still keep in touch with, was docked the equivalent of 1/4 of the source's pay for a year. In the eyes of the city bosses, it was more important to protect their secrecy than to celebrate a whistleblower, or in fact, to cure the problem that the whistleblower was trying to expose. It's awful what happened, and because I've not been released from my promise, I cannot tell the story properly, and I cannot publish it. That source did the right thing. If a court had asked me to reveal the person's identity, I would have gone to jail instead of talking. And we've talked a lot and we'll talk about a shield law, and it would be nice to have, but in its absence, I say two things. Journalists must do their due diligence to find out if a source is credible. And secondly, if they give a promise, they must give it with full knowledge of the consequences, and they must stand by it. Thank you.
Gail, could you give us your perspective and a U.S. one?
Sure. So I think what we've all heard today, both in this morning's discussion and this afternoon, is that sources truly are the lifeblood of journalists. And what I do every day is I work with journalists to help them get their stories published with manageable risk. And a lot of times what we're doing is talking about sources. And one of the first questions as an attorney for the company and for these journalists, and to keep them out of trouble, is who's your source? And second, what's your deal with them? And the word deal, that is a colloquial word, but what I'm really talking about in the legal terminology is it's a contract. When Kevin has that discussion of, I won't out you, that's not just a, hey pal, this is what we're doing. That's a contract, and it's binding. And it's not just binding on the reporter, but it's binding on you as a company. So when a journalist says, I will go to jail for you, that is a very big deal, because I don't want any of my journalists ever sitting in jail, especially for the source, as we were discussing earlier, who doesn't have the right motives or doesn't really have a reason to be telling you what they're telling you or any of those things. So it matters in the eyes of the law because what you've now entered into is a legal contract. The biggest problem, at least in the United States, and I think from what I've read here in Canada as well, is that you don't actually know what you're promising, given the current lay of the land for the law. The United States is a bifurcated system, and I'm sure I'm telling you something that you may already know. We are split up into federal courts and state courts, and that matters in terms of reporters and their sources because the Supreme Court decided in 1972 that the First Amendment actually doesn't provide reporters with any privilege not to testify against their sources. Having made that decision, which was a very ill-advised one, it left it open for the states and the federal courts to decide whatever they want to decide about what a reporter can do to shield his or her sources. That has led to total mayhem. And what that means is that I generally deal with reporters all over the world, but very often, let's say I'm talking to a Wall Street Journal reporter in New York. And this reporter says, I have a confidential source. The reporter and I agree that it is actually a confidential source, and by that I mean the discussion was not just, I won't put your name in the newspaper, it's that I will never tell anyone who you are. And I agree to that, and I will do everything in my legal power not to disclose you. So we agree, we have a confidential source. Let's say the story is about someone in the state of Oregon, and it has overtones about what the federal government is doing. I have no idea what to tell that source about what he or she has, or to tell my reporter what he or she has just promised the source. Because, for example, in the federal courts in the Second Circuit, which is where New York is, which is the federal courts that govern New York, the law is that you have a qualified privilege, and it's essentially a balancing test. And to me, when you start talking about a balancing test, you are essentially talking about the whim of a judge. And there you are saying to the judge, well, judge, you're going to have to balance. How much more important was it for the public to know the information that was provided by the source versus how badly do you really need it? And as we've seen over the years, the how badly do you really need it test can often depend upon the views of the judge. If it's a criminal case, you are going upstream. If it is a case about national security, you are in real trouble. If it is a civil defamation case, you have some arguments, but it's a qualified privilege. However, if my reporter is subpoenaed or called in a state court across the street from the federal court, I have an absolute privilege, and I can go in with that reporter and say, sorry, we decline to testify. The judge will say, fine, I'm going to cite New York State Statute, Section 79H, and you may leave. So it's literally the difference of which courthouse am I in. In the state of New York, at the same time, if it is a non-confidential source, meaning you've just kept their name out, or it's information you simply didn't publish, it is a balancing test, and it really comes down to how material is the information, how necessary is it, What has the other side done to go explore alternate sources? And then again, we do a balancing of First Amendment interests, interests of free speech, versus how much do we need this? So it's all over the map. With different states and in different federal courts, they all have radically different tests